rise. The Court of Appeals, Division 1, is now in session.
Thank you. Please be seated. Good morning, Council. We're here for oral argument in case number 1 CACV 16-0469, John M. Kasson, Jr. versus Clifton W. Burgener. Council would remind you that these oral arguments being video and audio recorded, so when you approach the microphone, if you'd please identify yourselves and who you represent. Each side will have 20 minutes for your argument. Appellant's counsel, if you'd please watch the clock and retain as much time as you wish for rebuttal. Also, please keep in mind we've read the briefs and we've discussed this morning, discussed the case this morning at conference. So with that, appellant's counsel, you may proceed.
Good morning, Your Honors. Thank you for taking the time this morning to hear our appeal. It's nice to be here. This case involves two parties that each signed a promissory note for $1 million to someone other than each other over 10 years ago. Mr. Burgener signed his note again more than 10 years ago. Approximately 4 months later, after that note had been assigned to the appellee entered into a collateral assignment wherein he transferred his rights under the note and the deed of trust to a third party who appear to have been family members. For 6 years from that point forward, nothing was really done. No payments were made, no efforts to collect. Suit was filed almost 7 years to the day after the collateral assignment by appellee.
Counsel, can I ask a quick question for background? Does the timing matter? I know you've mentioned the 10 years, the 6 years, the 7 years. Does that matter? How does that affect your argument at all as to the merits of the appeal?
Well, to the extent that the collateral assignment was recorded, it's noticed to the world, and it remains recorded today, I think it does. Sure, here we are 10 years after that was, in fact, it has been 10 years and a few days since that was recorded. So yes, to that extent, the collateral assignment and the transfer remains a public record, and everyone is deemed to know about it. And yes, I think if that answers your question, Your Honor.
Thank you.
And what I thought I would do today, and I expect you're going to have a number of questions, is simply talk about the cases that we found and the reasons why the answer to the question before the court today, who is the real party in interest and who has standing to file suit under collaterally assigned instruments. The first case that I located, that we cited, is the Shelter Development, which is a Florida case, and the law in Florida seems extremely well settled. In fact, they call it axiomatic, that the collateral assignee is the only one with the right to bring suit that has standing. What struck me about that case is it's a bankruptcy case, and under bankruptcy law, the creation of the estate is extremely broad. They cast this broad net because they want to bring in any possible assets to the bankrupt estate, and this was a debtor who was claimed, if I had filed an adversary proceeding for almost $1 million on two different notes, and the bankruptcy court said no. As a matter of law, the collateral assignee is the only party that can sue under these collaterally assigned notes and deeds of trust. The International Harvester case is a Mississippi Supreme Court case, I believe it's 1981, which made the same holding that the collateral assignee is the only one who can file suit, the real party in interest, under a collaterally assigned instrument. But what was interesting about that case, and it's one of the policy considerations here, is that the obligor to the collateral assignor, I don't know whether it got garnished, it's not clear in the opinion, but he paid what he owed the collateral assignor to the IRS to extinguish the collateral assignor's debt. And the Mississippi Supreme Court said that doesn't constitute payment because it had been collaterally assigned. You're obligated to pay the money to the collateral assignee. And so you had a situation where the original obligor paid the money to the wrong person, and the court said that's too bad. It doesn't extinguish your assigned debt to the collateral assignee. And this dovetails into some of the reasons why the policies behind this, the collateral assignee being the real party in interest of the assigned instrument, has the right to bring suit. It avoids multiplicity of suits. As I understand the law in Arizona today, without clarification, both the collateral assignor, and that's certainly the position of the opposing party today, is the collateral assignor can file suit on the note, and if the deed of trust still existed, they could move to foreclose under the deed of trust. And the banks routinely take these collateral assignments on lines of credit, and for what it's worth, I can assure everybody in this room, they think they're the ones that have the right to foreclose and enforce those instruments. Which brings another interesting point. The bank takes a collateral assignment, or in this case, the family members take a collateral assignment of the deed of trust. That's actually junior in time. And so normally, if the collateral assignor files a foreclosure action, it would wipe out the collateral assignee's security, which makes no sense at all, because the whole point of taking the collateral assignment is to have some security here. And that's why the argument that was advanced in the brief that no, all the collateral assignee really gets is when the collateral assignor collects the money, they then have to give it to the collateral assignee. Well, then what did the collateral assignee get if no security? I mean, the collateral assignor already, in this case, had an obligation to give $1 million to the collateral assignee. They didn't need a meaningless collateral assignment to reaffirm this right. The appellee was obligated under that note, the $1 million note to begin with. And so we have the case, the Burns case from the West Virginia.
Go further, Kate.
Sure.
What is the purpose of a collateral assignment? I mean, why do you think that these folks put the language in that they did to say collaterally signed, or you don't even have to use this particular situation, but explain to me then again, and perhaps you've covered, but maybe try to break it down in a level I can understand a little easier. Why would somebody do this then? Why would they do a collateral assignment? Because it seems like you're pointing out all these problems and risks and the narrow and all these nuances, and Arizona's but what is the basic purpose behind it?
The purpose to the assignee is to have security for its loan to the collateral assignor. It's to give it something more than it has.
And the assignor is what's their purpose? They're trying to at least hold on to something.
Well, in this case, the collateral assignor has borrowed $1 million from the collateral assignee before the assignment, and the collateral assignees are saying we want security for our note, not just a note that's a promissory note that we have to file suit to collect on. We want actual security so that if you don't pay, we can move to collect under what it is you assign to us, or we can move to foreclose under what you assign to us. The purpose is to give the collateral assignee security for the debt that the collateral assignor owes. Simply stated, Your Honor, that's my understanding.
Counsel, so your client still owes the $1 million and hasn't paid anyone, right?
Correct.
So why not simply, if he was foreclosed by one party, not simply join the other for a determination as to whom he owes?
I'm not sure I understand your question fully, Your Honor.
Well, your position is that the collateral assignor can foreclose on the debt.
No, my position is just the opposite. Mine is
that he cannot, because he has collaterally assigned the debt to the assignee, the collateral assignee.
Yes.
But what if okay, let's say, it's building on Judge Cruz's question, the debt has not been paid. What's your client's concern? If he pays the $1 million, could he interplead that money and have the court decide, look, we disagree with this. You could interplead. He could bring everybody to the table through a deck action. If he really was concerned about getting sued by 6 more people, couldn't he bring those people into court and say, let's have a decision once and for all who's owed and where this money goes? Going back to your situation about paying the IRS, I suppose that money could have been interpled into court and then said, I don't know, I'm paying this money, I'm not sure who's entitled to it, why don't you guys go fight over it?
It could have been, and if the case had taken a different procedural posture, I don't know what might have happened, and your question is, could my client have done it? Sure, I guess.
Well, can that still happen, though?
No, I don't believe so, because the collateral assignee is the real party in interest, and it's the one with standing, and it has not brought a claim, which dovetails into these are supposed to be family members. There's arguments about intent at the trial court. There's no affidavits from the collateral assignees authorizing the filing of the suit. They haven't sought to collect on the debt. And so if the intent was, the suggestion is that they don't know about this case, or certainly that they haven't authorized the collateral assignor to pursue this case. The easiest thing in the world to get affidavits and file those and to show what Appellee describes as the real intent in their brief. The real intent in their brief, and that's what the Burns case tells us, if you were going to show these things, you had a duty to bring it up at the trial court and not at the Court of Appeals. And so, I mean, it's a good question, Your Honor. And again, if we had taken a different procedural tact, if the collateral assignees had been part of the case, and that's what makes this issue so interesting is it can take permutations that we can't possibly cover here today in 20 minutes.
So couldn't your client have moved to bring them into the case?
Sure, he could have, Your Honor.
But that would have required then at the end to pay someone $1 million.
He could have, but I mean, respectfully, why would he? It's not his job to bring them in. It's not his job to seek out somebody to enforce the debt. It's the real party in interest and the party withstanding. If they want to get paid, it's their job. If they want to bring suit on this note, so.
I thought your position was that one of the reasons why your client can't pay is because of this confusion as to who has the right to enforce the debt.
I think it is. It is my client's position, yeah. Okay. But I think it's a big step from there to move to join somebody as a voluntary, involuntary plaintiff so that they can collect the debt from my client, Your Honor. Policies behind this, other things. Ruling that it is the collateral assignees has standing as the real party in interest. First of all, it's relatively clear in these briefs that is the majority rule. There are some cases that suggest a collateral assignor or both can do it, but the better policy, we argue, is that by designating the collateral assignee, who is actually the holder, who took this security so they would have that right, it avoids multiplicity of suits. It provides an obligor with certainty as to who they're supposed to pay, and it prohibits collateral assignors from bringing these type of actions that can compromise the rights of collateral assignees that have been assigned. And that certainly appears to be what has gone on in this case. And so it is simply the better reasoned, more enlightened approach, I submit. There is talk in the International Harvester case, and I believe in one other case, as to what the collateral assignor retains after the collateral assignee has exercised its rights under the assigned instruments, so an equity of redemption, which appears to be to the extent that the collateral assignor made payment on its obligation, it gets back from the collateral assignee what it's collected, to the extent that it exceeds the debt owed to the collateral assignee. So there is a remedy for the collateral assignor. They're not left without a remedy or in the dark. The point is they have to pay their debt to the collateral assignee before they can bring suit or have the right to collect on these instruments once they assign them. So I see I have about 4.5 minutes left.
No questions? Okay.
All right. Thank you,
counsel.
Good morning, Your Honor. May it please the Court, Barry Becker for the plaintiff appellee. I'd like to give a couple of brief statements on why these facts are particularly unique in a collateral assignment situation. Because when we read all these cases, they're always between independent third-party financial institutions which don't know each other. And they're in the business of lending and collecting money. But in this particular fact pattern, we have John Kasson, the plaintiff, who acquired a note from a gentleman named Joseph Urquhart and then collaterally assigned it to family members who are not banks, who are not financial institutions. And our position is that the relationship of a collateral assignor and a collateral assignee who's a family member just isn't the same as described in all the cases cited by the appellee, because the relationship is different. I would like to, I'm going to skip over some points because I'd like to address a question that Judge Cruz asked, and I think Judge Brown also referenced, which was, well, why didn't Mr. Burgener simply bring everybody into the case? There's no dispute he owes the $1 million. He doesn't say he doesn't owe the $1 million. He doesn't say that's not my signature. In the answer in the disclosure statements, he never makes any defense such as that. His principal answer is, hey, it was assigned. The reason that's important is if you look at the pleading number 32 in the amended electronic index. That was my response to their motion for summary judgment. Okay. The pleadings went like this. I filed a motion for summary judgment, and then they didn't file the response for approximately 6 months later because they asked for continued extensions to do discovery. In the disclosure statement and in the answer, the defense they now proffer to this court was never raised. The first time it was raised was in their response to my motion for summary judgment and their cross motion for summary judgment. In my response or reply to their motion for summary judgment, I said to the court, Judge, if you don't think my client, the collateral assignor, is a proper party, then we move to amend the complaint and bring in the collateral assignees, which are the Mr. Kasson's family members. And at oral argument on the cross motions for summary judgment, which the transcript is before this court, if you turn to that transcript, at the bottom of page 6, I said to the court, in my response on page 5, line 23 through page 6, line 10, I said, if the court believes that the collateral assignees are to be the proper parties, that is, Mr. Kasson's family members, then we move to amend the complaint to substitute John Kasson for his family members who are the collateral assignees. Later I said in the oral argument, if you believe the proper plaintiff is not Mr. Kasson as trustee of the John Kasson Trust, but rather the family members that he collaterally assigned it to, we request that you grant our motion to amend the complaint, which has not been challenged and has not been disputed, and then this issue goes away. So the trial judge never ruled on my motion because she determined that the collateral assignor was or is the party in interest. But if this court says, maybe the collateral assignee is the party in interest, then the proper thing to do is to simply remand the matter to the trial court and say, Judge, you need to rule on Mr. Becker's motion to substitute the parties. And where does that put us? It puts us right back where we were when I filed my original motion for summary judgment, which was Mr. Burgener signed a promissory note, hasn't made any payments, doesn't dispute he's made any payments, and we would still get a judgment between Mr. Kasson and his family members. So that's why this case has a unique set of facts that you don't find in all the other cases that generally describe collateral assignees, because typically the bank doesn't come in or the party who is holder of the note doesn't come in and say, hey, if I'm not the proper party, I'll let the other guy be the proper party. So we have a case where everybody who has a claim to this money or anybody who has a claim to this money says, we don't care who the proper party is. When I filed the lawsuit, excuse me, I believe John Kasson, the holder of the note, was the proper party. I will tell the court, I didn't even know it was collateral assigned. He didn't tell me. I don't think it made any difference to him. It didn't make any difference to the family members because they figured whatever's collected, they will take care of between themselves. That is why, in a typical case, when we say, well, what was the intent of the collateral assignor and the intent of the collateral assignee? It's a third-party relationship between some borrower and some bank. And we look to the intent of the agreement, and that's it. But in this case, we know that none of the collateral assignees have ever filed a lawsuit. We know the only one who's attempted to file the lawsuit is John Kasson. So it appears from those facts that the family members are relying upon their relative to collect the money for them. That's what we believe is the intent of the parties. If you say, well, we're not sure what the intent of the parties were, we're going to send it back down to the trial judge, and let the trial judge determine what the intent of the assignor and the assignee were, I will tell you, Your Honor, that's fine with me. All the family members are going to come in and say, our intent was to let John collect the money. Now, opposing counsel says, well, why didn't Mr. Becker just bring affidavits in at the time? There's actual two reasons. One is I truly didn't think I needed affidavits because I believed the collateral assignor, John Kasson, was the proper party, so why would I bring in an affidavit? And the way this case got presented to the court, this issue got presented late in the pleadings. Since it was never raised in an answer and it was never raised in a disclosure statement, I didn't even see this issue until 6 months after I filed my motion for summary judgment, when opposing counsel filed his response, and then I had the appropriate applicable period of time to get an affidavit. So it's not like it's an issue that I had 6 months to spot and round up these affidavits.
You mentioned discovery. There
was no discovery. There's been no depositions taken. There's been no interrogatories taken. The sole discovery in this matter is the exchange of disclosure statements. And if you look at my motion for summary judgment, which is exhibit number 7 in the electronic index, filed August 7, you'll see it's pretty short. I mean, I don't remember how long it is, but it's only 3 or 4 or 5 pages. It says something like, the promissory note was signed, the promissory note has not been paid, these are the dates, and there's a default. And here's how we calculate the amount of the damages. So there was no discovery. And this issue was not raised until the response cross motion. I didn't bring in the affidavits because I quite frankly believe, and I still believe, that I am accurate in saying John Kasson is the proper person to enforce the terms of the note. And I say that for a couple of reasons. One is we know that his family members have not filed a lawsuit, so they must be looking to him. Or alternatively, he's making payments to them on his obligation to them, and they don't even know the Burgener note's in default, nor would they care. So from a public policy viewpoint, you have this relationship, Burgener to Kasson is one contractual relationship. Kasson to his family members is another contractual relationship. And if Kasson is making payments to his family members, as he's supposed to, they're not going to file a lawsuit against Burgener because there's no default as it relates to them. They're getting the payments that they're supposed to get. That is why, as a matter of public policy, it makes no sense in a family relationship where you don't have banks and financial institutions to say collateral assignees, while you don't know what's going on with the original underlying note, and while you are receiving payments, you are supposed to file a lawsuit against Mr. Burgener who's not making any payments. That doesn't make any sense. Now, opposing counsel cites two cases, and I would just like to reference them. He cites the International Harvester case. But when you go read the International Harvester case, there's a sentence in there that says, and again, it's a case with very little discovery. Apparently, promissory note cases don't generate a lot of discovery. But there's a line that says, there was substantial evidence in this sparse record to support a finding by the trial court. The assignment was unconditional and absolute, thus dissipating this contention. Later, next paragraph. While the note executed to People's Bank was signed by both Walden and Mrs. Kane individually, neither Walden or Kane were made parties to the lawsuit, indicating an understanding the assignment was complete. So in that case, they come to this conclusion, then they go on and say, and we talk about collateral assignments, but the court says, we believe the assignment was complete. Then, in the case cited by opposing counsel called Burns versus City Services, which is a case out of West Virginia, the court writes, at the time summary judgment was awarded by the trial court, the record disclosed a complete and unconditional assignment of the proceeds of the contract. So in those cases, not only are they involving financial institutions between people who negotiated at arm's length, but at least the trial court's record, which was spotty, indicated to to their appellate court that the trial court thought this was a complete assignment. So you can't really rely on those cases. Additionally, Your Honor, in deciding what the policy is for the state of Arizona, since we have no cases apparently have no cases on this issue, we don't count noses. We don't say, well, West Virginia and Kansas and Mississippi and North Dakota or whatever it is have ruled, and we add them up. There's 26 cases in one side and 24 on the other side. That's not the way the law of Arizona is judicially determined. We look at it and say, what makes sense? So what makes sense in this case from our perspective is, one, what evidence do we have to indicate the indication of the intent between Kasson and his family members? Who did they think was going to enforce the Burgener note? Two, if you truly believe that the 7 collateral assignees, which, by the way, would mean that Burgener, under the defendant's theory of the case, absent questions of the statute of limitations here, which have now expired, but we filed timely, Mr. Burgener could have been sued 7 times instead of 1 time. And of course, the issue would then be, if Burgener had some defenses, the collateral assignees, the family members, may not even know what they are or have the sufficient documentation in their possession. Because Burgener could say, well, I didn't pay you, I've been paying Mr. Kasson. So it makes more sense in our mind, in this set of fact pattern, to say Burgener and Kasson have a relationship. Kasson and his family members have a relationship. One last matter, Your Honor, or Honors. I think you asked the question, someone about the collateral and, well, what was the purpose of the collateral? Again, this fact pattern is both unusual and a little screwy, because the note that Burgener signed was in second position behind another note to a bank. And both the first, and this is in the record, this is in the statement of facts. The first note was secured by a piece of real estate. The second note Burgener signed was secured by the same piece of real estate. Burgener defaulted on both notes. The bank held a trustee sale on the underlying real estate that was held as collateral. Because we were in the middle of a recession, that real estate was worth less than even the first note. So the holders of the second note with the deed of trust didn't do anything to protect their interests, because now this problem, the real estate collateral, was deficient. So while we start this transaction secured by real estate, we end this transaction by an unsecured note. And so when you ask, well, why didn't Mr. Burgener, or why didn't the family members just foreclose on the collateral that was originally the collateral for this promissory note didn't exist. It had been converted from a secured promissory note to an unsecured promissory note. So the only action anyone can take against Burgener is not to foreclose on the real estate, because it's gone, but to sue on the note. So who's supposed to sue on the note? Our position is Kasson sues on the note. He knows what payments have been made, haven't been made. The record shows that he had been negotiating with Mr. Burgener on a settlement, although it never occurred, and that for that reason, Kasson is the proper party.
And the record also shows that your client is the holder of the note as well?
Yes, the record shows that this note was signed by Mr. Burgener, payable to a person named Urquhart. Urquhart assigned it to Kasson, and Kasson collaterally assigned it to his family members. But somewhere in that chain, after Kasson got it or his family members had it assigned to him, the real estate, which was collateral for the note, went away during the recession. So our position, Your Honor, is Mr. Kasson is the proper party. He's the person who knows the facts the best, most likely to enforce the terms of the note, and in accordance with the terms of the note. But if you believe that I'm wrong, then the proper recourse for this court is to simply say, we're going to remand this thing back to the trial court until the trial court to amend or to consider Mr. Becker's amendment. And then we're going to end up with another judgment, and it seems like a judicial waste of time. If you have any questions, I'm happy to answer. If not, I'm happy to sit down.
Thank you, Counsel.
Thank you very much.
Thank you, Your Honor. Lawrence Lind here again. I was trying to listen closely to arguments being made here, and I don't know that I heard one single case cited or argued by appellee that supports the position that a collateral assignor is the real party in interest or has a right to sue under collaterally assigned instrument. Not one case.
What about, I'm a bit confused, because it seems to me there's no collateral left. There is no collateral.
The note is the collateral.
Itself. The note, that's it, but there's no real estate collateral.
Right.
And the shelter development case you talked about, that refers to, if I'm reading, unless I'm reading it wrong, that merely says that the assignee, where it says the assignee is the real party, that's the real party who can foreclose. It doesn't say anything about suing on the note.
At that stage of the litigation, I believe it was a mortgage, and they were suing on the note and to foreclose. And they ruled that the assignor could
So
not.
are there other cases that clearly say, when there's no real estate, you cannot sue on the note?
Absolutely, Your Honor. I believe it was the beneficial case out of the federal court in Pennsylvania, where they cited a Judge Hand as
563F sub 113.
there's another case where the seller, he had a note, and he assigned the right to receive the note to the bank because the bank lent him money. There's several cases that I cited, Your Honor, at least 2 or 3, that did not involve real estate.
Do you know if in those cases, the person who was attempting to bring suit was actually the holder of the note?
Most of these cases involved a collateral assignor attempting to sue on a note.
But did the collateral assignor in those cases have the note in his or her hand? And is it your position it doesn't matter?
It doesn't matter. He's assigned the right to it. He might have a
Isn't a
copy
note a
of it.
valuable instrument?
Well, sure, but if you assign it to someone else, you don't hold it anymore. Which brings me to this whole notion of family members, and we're going to base the law of collateral assignments in Arizona on the whim of alleged family members. By the way, there's nothing actually in the record that all these people that are the collateral assignees, I think some of them have the same last name, but not all of them. This is not even part of the record. You know, counsel says maybe Kasson was making payments under his $1 million note. Hey, this is the Court of Appeals. If they wanted to build this record, their job was to do it at the trial court. By the way, there is no motion to amend filed at the trial court. There never was. There's a passing reference to it in a pleading, but for a number of reasons. First of all, I don't think it's even a motion to amend. You're talking about an independent party. If Chase brings an action and they've assigned it to Wells Fargo doesn't join the lawsuit. Wells Fargo has its independent claim. But ultimately, this whole motion to amend is a red herring because nothing was ever brought. And they knew about it. They knew what our defense was at the trial court. They didn't disclose the collateral assignment. Somehow we found it ourselves, which is why it got raised when it did. So, you know, if the record hasn't been built appropriately at the trial court, that's the West Virginia Supreme Court Burns case, says that's the collateral assignor's problem. If you wanted us to consider these issues on appeal, then you should have brought them up down there. Finally, this was a complete assignment of everything that Kasson held under the note, the $1 million. This is not a partial assignment where there's this mixing of one as the other. They're both $1 million notes, and he assigned all that he was owed under the Burgener note as part of that collateral assignment. I am out of time.
Okay. Counsel, thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. We'll take a brief recess to prepare the courtroom for the next argument.